I didn't hear. Good morning, I'm Judge Woolley, and I'll hear the arguments on the Norma Rosales versus several defendants case. I'll start to make sure I know just who are still the defendants in the case. Ms. King, would you bring me up to date on just who you wish to have as the defendants?
Yes, Your Honor.
And by the way, do we have Ms. Norma Rosales on the phone?
Yes, Your Honor. She is
All right.
available.
Good morning,
on
ma'am.
the phone.
Good morning.
The current defendants are the Department of Education, Indian Hills Community College, the Board of Directors for Indian Hills Community College in their capacities as members of the Board of Directors and individually. Jim Lindenmeyer in his capacity as college president and individually. Kelly Conrad in his capacity as Dean of Students and individually. Livier Leffler in her capacity as Dean of Academic Services and individually. Thomas Stewart in his capacity of Director of Indian Hills Community College Foundation and individually, and Mary Stewart in her capacity as Dean of Academic Services and individually.
You are no longer bringing this lawsuit against Governor Terry Branstad nor Mr. Buck.
That's correct.
And just briefly, before I turn to the arguments in support of the motion to dismiss, what is the essence of the lawsuit that Ms. Rosales is bringing against all those defendants?
The essence of the lawsuit is that she was constructively discharged from her employment, which denied her rights to procedural due process and also her fundamental rights under the Privileges and Immunities Clause of the 14th Amendment, and that she was denied equal pay under the Equal Pay Act.
And what is her, what is the thrust of her contention as to each of those defendants? Why are there so many defendants?
Because so many of them treated her so cruelly and caused her to be so psychologically affected and demoralized that she became unable to return to work.
So you are seeking the total damages against each and all of the defendants?
Yes. Well, collectively. I mean,
What I mean is if the jury, if the case went to a jury,
Yes.
decided that there had been a total of $100,000 damage, would each of those defendants be responsible for the whole amount?
no, Your Honor. They would jointly be responsible for the $100,000.
Well, that's the same thing, isn't it? Would the jury, in other words, or the judge, if it is a non-jury case, have to decide what percentage of those damages each defendant was responsible for?
Yes, Your Honor.
And how would that work? What is the measure of damages?
I guess the amount of damage that they caused by, the persistence of how they mistreated her and the number of times that they mistreated her.
Well, how would the jury or the judge possibly allocate to individual defendants actual measured damages?
I believe based primarily on the evidence presented by her medical records from various therapists and psychiatrists she's been to.
Wouldn't all of that be a single lump dollar amount?
Yes, I believe it would be.
So it wouldn't have to be allocated among individual defendants.
Perhaps not, no. I had considered it a lump amount, and I guess the way you phrased your question caused
I
me
just
to
don't
rethink
understand
it.
why there are so many defendants and how each one could have caused the full amount.
No, each one could not have caused the full amount, and that was why I revised my thinking based on the question you asked, that it wouldn't be fair for a person who was cruel to her once or twice to pay as much as a person who was cruel to her 100 times.
But the way the prayer of the lawsuit is phrased, each would be responsible for the whole amount. Each defendant.
I believe that just, one amount would be decided upon, and that they would be responsible. Yes, each of them would be responsible for that.
All right, thank you. I couldn't quite figure out how all of these defendants became parties to this lawsuit. Now, who will make the arguments on behalf of the defendants? Bracken?
Actually, I believe Mr. Porter will. Your Honor, my name is Rob Porter. I'm the Assistant Attorney General. I represent the Department of Education. The state defendants filed this motion. I'll be making the arguments.
All right, and as to the other individual defendants?
We don't have an issue in this particular motion, Your Honor.
And so you are proceeding with your answer and as though the case would go to trial?
Yes, sir. We have filed an answer.
Do you anticipate that there will be dispositive motions before the case actually goes to trial?
Yes, sir, we do.
All right. And now, Mr. Porter, I'll hear the arguments on behalf of the Department of Education.
Thank you very much, Your Honor. At the outset, as you've heard, this is basically an employment-related suit that the plaintiff has brought against her former employer, Indian Hills Community College, several individuals who are related to that college. She had originally brought suit against the governor and Director Buck, in addition to the Department of Education.
And can you hear Ms. Rosales?
Yes, sir.
Thank you. Okay. Continue, Ms. Porter.
My apologies. My apologies. The sole remaining state defendant in this case is the Iowa Department of Education. We're going to respond to the amended pleading the way she has it currently phrased, because she also dropped 5 of her 7 claims against the defendants. The existing claims, as I understand them, are a constructive discharge claim and an Equal Pay Act claim. There are numerous problems with pressing both against the State Department of Education. A few of them briefly are, it's presumed based on the way she's described it, that Section 1983 is the vehicle for her enforcement of her claims. As you know, a state agency is not a person for the purposes of a 1983 claim. We can't be forced to defend a 1983 claim. That's black letter Supreme Court case law. Also, a damages claim against the state of Iowa has to first presume through a state tort claims process under Iowa Code Chapter 669. There's been no evidence that any of that has been undergone or that the state has given her right to sue under that statute. Even if she had, the exclusive jurisdiction of those sorts of claims is Polk County State Court, not the United States District Court. One of the most fundamental issues is with respect to the constructive discharge claim, the state has 11th Amendment immunity from suit in federal court. Absent a state waiver or congressional abrogation, we can't be sued in this venue. We clearly don't have state waiver, notwithstanding the plaintiff's arguments relating to an Equal Pay Act claim, which the state wasn't even involved in. If you look at the remedy provision, and even if the state was, that deals with what you can sue the state over, not where you can sue the state. We're just in the wrong venue. We can't be sued for this claim in federal court, the constructive discharge claim. There's an underlying issue that affects not only constructive discharge, but also the Equal Pay Act claim. even under the most lenient pleading standards, there is no allegation whatsoever that could lead to the conclusion that the Iowa Department of Education was Ms. Rosales' employer. The Equal Pay Act only, by its own express terms, only applies to discrimination by employers. The constructive discharge, again, relates to an employment-related action taken by an employer. There's no allegation that we hired Ms. Rosales, we being the Department of Education, no allegation we set her work duties, no allegation we set her pay, that we supervised her work duties, that we did anything with respect to her work that could in any way, even under a gracious pleading standard, be labeled as an employer for the purposes of either of these claims. The only claim she makes is that we have certain statutory obligations with respect to the oversight, primarily of the accreditation and academic process of community colleges, and she's arguing respondeat superior liability. That, Your Honor, does not change the fact that we have nothing to do, according to this petition even, with her employment. And there's been no allegation of such, and we believe none is going to be forthcoming. We're just the wrong party in the wrong venue in the wrong case. Ms. Rosales has clarified to some extent, and we appreciate that clarification pre-hearing, but we still believe we're entitled to dismissal as a matter of law at this point.
Would it be a dismissal with or without prejudice? Because you have suggested the lawsuit could be in the Iowa District Court rather than U.S. District Court.
With respect, certainly with respect to the constructive discharge claim, the court could determine that the jurisdiction is wrong, and therefore it could be a discharge without prejudice. It seems to me that the Equal Pay Act is more of a fundamental problem because it doesn't raise the same jurisdictional issues and because of the express statutory construction relating to the liability of employers. It seems difficult to get around a conclusion that would allow refiling on that claim in state court. You could make that determination on the other claim if the court was so inclined.
And Mr. Bracken, you take no position on the case?
That's right.
All right. Ms. King, now you may respond to the forceful arguments on behalf of the Department of Education.
Your Honor, with due respect, I would like to state that it is my position that the statute giving the department supervisory capacity over community colleges, Section 256.1b, places the Iowa Department of Education in the position of respondeat superior over the community colleges of the state. The responsibilities of the Department of Education are unclear. Section 256.6.1b gives the department general supervision over the state's community colleges. The definition portion of Section 256.2 omits a definition of general supervision. Most of the cases cited by the state, and all of them, in fact, which I have read, do not apply to a statutory scheme in which a state agency is placed in a supervisory capacity over parties to the lawsuit, which is the case in Ms. Rosales' claims. She was denied procedural due process due to the nature of her discharge. Her discharge was constructive and took place over time. It was psychological in nature, rendering her eventually too demoralized to return to work at Indian Hills Community College. For this reason, she was never given the opportunity for a hearing. Her formal discharge came in a letter based on her inability to return to work and the college's policy pertaining to that. Norma Rosales received IPERS as an employee at Indian Hills Community College. Since this is a retirement program for state employees, she must be considered to be an employee of the Iowa Department of Education because there is no other state agency that she could have been employed by. The Privileges and Immunity Clause was violated because Ms. Rosales was denied a fundamental right, the right to be treated in her workplace in a manner that would even allow procedural due process, and also which would not be hostile.
So in what way or by what course of action would the Iowa Department of Education have corrected or prevented violation of due process as alleged?
I believe the flaw lies in the vagueness of the statute. It doesn't really clearly define what the supervisory duties are, but it does seem to me that without any responsibilities coming with this supervisory capacity is just an empty statute that means nothing. Under the current system, I believe they could at least follow up with each of the community colleges in the state to determine whether they are following procedural due process in termination of employees.
So at what point of time do you believe the Iowa Department of Education and its personnel failed in performing a duty owed to Ms. Rosales?
I'd say that it would be at the point in time when she became unable to return to work.
And what would the Iowa Department of Education have done in her case?
I would think they would have met with the Department of Human Resources at the community college and with Ms. Rosales and tried to resolve the problems that were going on there.
Do you concede that the Iowa Department of Education was not the employer of Ms. Rosales?
Well, no, I don't, because she was receiving IPERS and she worked in education. There was no other department that she would have been employed by that would have qualified her to be a recipient of a state employee retirement program.
So persons employed by departments of the state who are entitled to receive IPERS benefits must be employees?
Yes.
Ms. Porter, what about that argument?
Thank you, Your Honor. First of all, the argument that IPERS only applies to state employees is specious. Iowa Code Chapter 97B sets forth the public employees that are eligible to participate in IPERS. Those would include not just state employees, but city, county, municipal employees, any number of people who would not be state actors under state law. So the fact that she's a public employee eligible to IPERS is not in any way dispositive to whether or not she's a state employee. As a matter of fact, courts that have reviewed this issue have determined that community colleges employees are not state employees for the purposes of the State Tort Claims Act, and they're not state agencies for the purposes of 11th Amendment immunity because community colleges are so unique and independent under Chapter 260C, they are not synonymous with state governments and state employment. So not only does Chapter 97B, the IPER statute, not support the plaintiff, case law doesn't support the plaintiff either.
How do you reply to that very strong argument concerning the fact that IPERS covers many people who are not direct employees?
By pointing out that she was an employee of an institution that is by statute to be supervised by the Department of Education. And also I'd like to say there is very analogous state law in the case Lincoln versus Board of Regents of University System of Georgia. This was also a constructive discharge case. And it did result in a finding that the Board of Regents was liable to the person who was constructively discharged. And none of the other cases cited by either party to this is nearly as factually on point as this case. The site of it is 697 F 2nd 928.
Final arguments on behalf of Ms. Rosales.
Ms. Rosales was employed in an institution over which the State Department of Education has supervisory capacity, and she was denied of fundamental rights of due process and of procedural due process. And I believe that the code needs to make it more clear exactly what the Department of Education is to do in their supervisory capacity of community colleges, and that Ms. Rosales is entitled to relief and remedies from all of the defendants, including the Iowa Department of Education.
Final argument in support of the motion to dismiss the Iowa Department.
Thank you. Just briefly, regardless of theory, regardless of outcome, it's very clear that under the 11th Amendment, there is no ground for bringing the constructive discharge claim, and under the Equal Pay Act, for the myriad of reasons raised in this case, this Iowa Department of Education is not the plaintiff's employer for the purposes of the statute. So, rather than rehashing all of the arguments in the existing briefing, we would rest on our motion and ask that the department be dismissed from the suit.
The court grants the motion to dismiss as to the Iowa Department of Education, and that ends this hearing. I believe that the arguments on behalf of the Iowa Department of Education are much stronger than those proffered by Ms. Rosales' attorney. One concern I have as a practical matter as one looks ahead to a jury trial, and there is a jury demand in this case, is that the plaintiff be sure she has the correct one or more defendants, because the worst outcome for her would be to have a jury return a verdict against, just as an example, somebody named Kelly Conrad and no other defendant, even though that was not a solid defendant for her to obtain relief from. That would result in no satisfactory outcome for Ms. Rosales. I think the plaintiff would be wise to select that one or more defendants against whom, if a verdict was against any one defendant, that verdict would stand up on further final result. The case would likely be submitted to the jury as to all defendants who remain in the case, and the problem the plaintiff's attorney may have is to have the wrong defendants as the persons who the jury decides should be held responsible. But it is plain to me that the Iowa Department of Education under the Iowa statutory scheme is not liable in this case on either the equal pay or the 11th or the due process claims. And I think the 11th Amendment also protects the department. Thank you. Have a nice day.
Your Honor, is it the dismissal, is that with or without prejudice?
I'll have to determine that.
Okay.
Your view is what?
That it should be without prejudice?
And the reason you need it without prejudice is for what purpose?
For pursuing the claim against the department under the Iowa Torts Claim Act in state court.
And would that be only against this one defendant and not all the other defendants? you have a problem of splitting your cause of action
Yes.
by being in different courts. Or would you bring it as an Iowa State tort liability against all the defendants?
I'm not sure at this time, Your Honor.
All right. Well, you'll have to make that a decision. But at this time, I find that there is no merit in the claim against the Iowa Department of Education, so the dismissal is with prejudice as to the claim in this court.
Okay.
Thank you. Goodbye.
Thank you, Your Honor.
Thank you.